Let's talk about crossing defense experts. We know from this DUI mock trial video that the defense has brought forth an expert who is a retired police officer who now testifies for defendants at jury trials. Let's take a look.
Early line to you.
Thank you. So you were a state trooper for 15 years, is that right?
Yes, ma'am.
And during that time you worked patrol?
Yes, ma'am.
And you taught at the State Police Academy also, isn't that true?
For a period of time, yes.
And part of that training at the State Police Academy included training other troopers and other officers who attended in how to conduct the field sobriety test, isn't that correct?
Yes, ma'am.
Under the NHTSA guidelines as we've been talking about today, correct?
Yes, ma'am.
You were also, you mentioned part of the breath test unit, correct?
Yes,
So you were a breath test operator and a breath test technician, correct?
I was.
So you are very familiar then with the training manual and the guidelines advocated by the National Highway Traffic Safety Administration for the administration of all 3 field sobriety tests. Is that right?
Yes.
You noted that there was bright sunshine on that particular day. But when you saw the video, did you hear the defendant complaining that the sun was in his eyes?
No, I did not hear that.
From the angle of what you were able to see on that video, did it appear that he was doing what he was supposed to be doing for the officer during the HGN test?
It appeared, yes.
Further on the walk and turn test, the NHTSA guidelines indicate that it's not actually required that there be a physical line, so to speak, such as in this carpet, in order to perform that test for the walk and turn test, correct?
It is not required, no.
Also, it is not, we'll strike that. You had an opportunity to observe the video, isn't that right?
Yes, ma'am.
And you saw it at least, how many times would you say you reviewed it?
Approximately 2 to 3.
2 to 3 times. And when you reviewed that tape at the very beginning, it's actually just kind of the empty road. Isn't that fair to say? Before you first see the car come into view.
Yes, that's fair to say.
The trees were still, weren't they?
At what point?
When the video first starts, before the car appears into it, the trees are absolutely still, aren't they?
I believe the tree trunks were not moving, but I believe I remember seeing the leaves shaking due to wind.
Okay. Yeah. Did you see the trees bending in the wind?
At that point in time in the video, no.
No. And as a matter of fact, the background, once the car stopped, is a building, isn't it?
There is a building in the background along with another tree.
There's actually light poles in the background, aren't there?
Yeah, I believe so.
Okay. Did it appear that anybody was having, that the officer was having difficulty in standing because of these big wind gusts?
Due to the officer's stature, it didn't appear he was having any difficulty standing.
All right, and he was standing in the exact same manner at one point in time that the defendant was standing, with his right heel in front of his left toe, wasn't he?
For the brief demonstration,
And
yes.
he was demonstrating the test. He took 3 steps up a line and he took 3 steps back, correct?
That is correct.
And he didn't appear to have any trouble doing that, did he?
During the brief demonstration, no.
It was only the defendant who had been drinking alcohol who was having problems performing the walk and turn test. Is that right?
That's an argumentative question. I object.
I'll sustain the objection and strike the question.
You indicated that your concern with the judgment call, as you put it, I think, on the turn, on the improper turn, that shouldn't have been counted against the defendant. Is that fair to say?
That's fair to say.
But you would agree. But you would agree, wouldn't you, that you still observed the defendant not be able to maintain his balance when he was told to stand with one heel in front of the other, correct?
Yes, that's correct.
Okay. He fell off that line, so to speak.
He stepped off the line, yes.
And that would be one of the indicators of impairment, isn't it? One of the
One of-
clues that they look for.
For that particular test, yes.
Yes. You would also agree that he missed heel to toe on at least 2 separate occasions based on the officer's testimony and observations of the video. Isn't that fair to say?
It's fair to say.
And that also would be a clue that you would look at. Isn't that true?
Yes,
Finally, he's clearly stepped off the line on 2 or 3 occasions during that walk and turn test, didn't he?
yes,
And again, that is another clue that leads to an officer's conclusion, ultimately, of impairment for that particular test, isn't it?
yes,
You also conceded that, well, if he did anything, he took the improper amount of steps.
yes, I did.
Okay. And that's also one of the standardized clues for the walk and turn test, isn't it?
Yes, it is.
So if we talk about the losing his balance when he was being instructed how to do the test, and we add that to the heel to toe, missing heel to toe, and we add that to the stepping off the line, and we add that to your clue of taking the improper amount of steps, that's four separate clues that you see, correct?
That's correct.
What is the NHTSA standard for the number of clues to look at for the walk and turn test as an indicator of impairment?
The standard would be 2.
2. So either way you look at it, it's plenty enough necessary for a decision on impairment for that test. Isn't that correct?
Yes.